Well, the next one is unenforceable contract. Well, it is a contract which cannot be enforced by the code of law because of some technical defects such as absence of writing, registration, requisite stamp, etc. When the technical defects are removed, the contract becomes enforceable. Example: C borrows rupees 1 billion from B and makes a pronote on rupees 10 stamp paper. It is unenforceable because the pronote is undervalued. So there is a technical uh, missing over here. F. Illegal agreement. An agreement is illegal if it is forbidden by any law. Such an agreement can never become a contract. An agreement is illegal and void if it is forbidden by law or is of such nature that if permitted, it would defeat the provisions of any law, or is fraudulent, or involves injury to the person or property of another, or the court regards it as immoral opposed to the public policy. A collateral agreement to an illegal agreement is also void. A collateral agreement is secondary to the main agreement. The parties to an illegal agreement are not responsible to perform their promises. There is punishment for parties according to law. There is an example. C gives money to B, a smuggler, to buy smuggled good. The agreement is illegal and the money cannot be recovered. Next, another example. A borrows rupees 2 lakh from B to buy a car from X to carry out a bomb blast. B knows the purpose of the loan agreement between A and B is collateral to the agreement with X, so it is illegal and void. If B is not aware of the purpose of the loan, he may recover it from A. Well, the next one is according to the formation. We are talking about the classes of contract, and earlier we were talking about the technicalities on the legality, and now we are talking about the technicality and the classes of contract on the basis of its formation. So, if we talk about the formation, there is express contract. An express contract is a contract where the parties state the terms of words spoken or written at the time of its formation. When such a contract is formed, there is no difficulty in understanding the rights and obligations of the parties. In express contract, the parties directly state the terms of the contract. There is an example. A tells on telephone to B that he wants to sell his car, and B informs A that he agrees to buy the car. It is an express contract. Well, implied contract. An implied contract is made otherwise than by the words spoken or written. It arises from the acts and conduct of the parties or circumstances of the particular case. It arises when one person without request renders services under circumstances indicating that he expects to be paid for them, and the other party, knowing such circumstances, accepts those services. Example: B went into a restaurant and had a cup of tea. It is an implied contract and B must pay for the cup of tea. M is a shoe shiner, starts polishing the shoes of W in his presence, and W allows him to do so. It is an implied contract. Of course, they don't express the terms. It is understood that if one goes to a cobbler, got to pay him for the service. If one goes to the restaurant, got to pay for the service. Understandable, quite understandable. Another example: B withdraws rupees 25,000 from ITM of a bank. It is an implied contract. The other one is a quasi contract.